Welcome to today's webinar titled ABCs of Tort and MVAs. My name is Jeff Hanlon, and I'm pleased to host today's program featuring Michelle George, Joel Radamisis George, and Stanley Pasternak Injury Law Professional Corporation. If you experience issues or need assistance, you can contact the OLA office by calling 905-639-6852. This program is sponsored by Seahold, Plaintiff Financing Made Easy. The webinar is eligible for up to 1.25 substantive hours. We encourage you to ask questions throughout the webinar. Submit a question at any time using the questions panel right near the bottom of the GoToWebinar interface. You can also email me your questions to jhanlon@otla.com. That's JHANLAN@otla.com. We'll try to answer as many as possible at the end of the program. Our presenters have made a PDF copy of their slides available to you for today's presentation. You can find the PDF in the handout section of your GoToWebinar interface. I'd like to take a moment to introduce our speakers for today's webinar. Stanley Pasternak attended the University of Toronto Law School. After his graduation in 1975, he was called to the Ontario Bar in 1977. His practice is restricted to seeking settlements in personal injury, disability, and insurance cases. Stanley Pasternak's cases have been featured in Law Times and the Toronto Star. He has published articles in the Litigator, the Journal of the Ontario Trial Lawyers Association, and presented at several trial lawyer conferences. Michelle George has represented injury victims and their families in many levels of court, including the Ontario Superior Court of Justice. She has acted as counsel at trial and represented individuals before the Financial Services Commission of Ontario, Canada Pension Plan Review Tribunal, and the ODSP Tribunal. Michelle is a past director on the board of OTLA and a former state delegate and board of governor for the American Association for Justice. She is the president of the Federation of Portuguese Canadian Business Professionals. Michelle has co-chaired and lectured at conferences held by many organizations. She has also written for the Litigator. Michelle is fluent in Portuguese and Spanish. Ms. George and Mr. Pasternak, thank you for being with us today, and I welcome you to the program.
Thank you. Good afternoon, everyone, and thank you for joining the program. So Stan and I are going to try to cover 4 topics today that could probably take 4 days to cover, but we're going to try to do this all in 1 hour, so bear with us. So
Michelle, sorry to interrupt. Can you just pop up your presentation?
Yes. Do you have it there?
Perfect. Thank you.
You're very welcome. Sorry about that. I am going to be discussing the initial intake, preparing the client from day one, and giving some points on building the file, and Stan is going to cover discovery prep and mediation and pretrial preparation. So what we at our firm, we spend quite a bit of time meeting with clients on day number 1. By the time that a client meets with a lawyer for the initial intake, they've probably already spent at least 20 minutes on the phone with somebody, sometimes a lot longer. And our initial intake meetings usually take about 2 hours. And why do we do that? We do that because we want to make sure that, first of all, the client that's, or the potential client that's coming in is someone that we are in a position to help. And secondly, we want to make sure that we're starting to build our cases right from the intake. So we start to get very detailed information right from the beginning. I've put some of the details in here from what we gather for the purposes of our file summary. We start gathering some background information. When they tell me, for example, about their marital status, I'm not just thinking, you know, are they married or are they not married? I'm thinking, okay, is there someone at home that they were sharing responsibilities with? What's the division of financial responsibility? Can this person afford to stay home from work? What will the other side be thinking is their motive for being off of work? I'm not just taking the information literally as it's coming to me. I'm already planning and thinking and trying to anticipate what what will be coming at me in the future against this client, and what will help support this client's position. Children, are they young children? Are they in school? Are they away at school? Do they have grandchildren? Do they need an interpreter? That will impact job options. What's their level of education, both back home and here? This starts to paint a picture about what kind of person this client is. We want to get information about who lives in the home so that we can understand whether or not this person had other people that would help, for example, snow shovel or cut the grass. We want to find out information about their pets. If somebody has a significant injury, they might not be able to walk their dog and they might have to hire someone, and that's a loss that they've suffered as a result of their involvement in a collision. We want to find out information about religious affiliations and volunteering. So why is that important? It's important because we want to know about what it is that they can no longer do and what was important to them, but we also start to explore potential lay witnesses that will be incredibly supportive and helpful to the case in the future. For example, if somebody is volunteering at a church every week and, cooking for the homeless, and there's a priest there who's able to write a letter supporting that and saying how wonderful and helpful that person is and how they haven't been able to come back to doing any of that since the collision, we want to know about that. Do they have a lot of volunteer experience? That speaks volumes about who they are as a human being. That's very supportive about their character and also about how active they are in their community and in general. We want to find out about previous injuries. Have they been involved in any motor vehicle collisions, any slip and falls, any WSIB injuries? And we specifically ask these questions because if you just say, have you been in an accident? They're just thinking car accidents, for example. They're just thinking about collisions. But it's important to find out all of that information and also to find out whether or not they've been involved in any litigation as a result of a previous collision or slip and fall. And it's important for them to be told that if they are asked whether or not they have been involved in any motor vehicle collisions or any slip and falls where they've been injured, they should admit to that. It's important not to withhold that information. Sometimes clients are not intentionally trying to withhold the information. They just don't think it's relevant or it just doesn't come to mind. Then that can cause credibility issues in the future. So it's important to dig into all of that and get all of the background information. We spend quite a bit of time trying to find out about pre-existing medical problems, previously diagnosed conditions, what medications were they on, what surgeries have they had, did they have any issues with pain and limitations as a result of these pre-existing medical problems. And once we explore that, then we make the clients understand how important it is that they provide this information when they're asked, whether they're asked by a doctor that we send them to or by an IE assessor. It doesn't matter. It's important to face this head on. When I get this information, if I start finding out that there is a lot of pre-existing medical problems, but it's still a case that I think that we should be pursuing, then at that point I also start thinking about the fact that I might have to do treatment charts or prescription charts or both. So that's something that I'll put in my notes when I'm assigning tasks on the file so that my clerks know that this is something that I would want in the future. So what I mean by that is, for example, let's say the client was taking a pain medication and a sleeping medication before the collision. Maybe they were taking one pain medication per day and one a sleeping pill right before bed. And that's something that they did for years. And that is something that will be used against us in the case. At that point, what we would do in building the case, and I'm kind of, I'm speaking about both of the topics right now, is we will look at the prescription information and we will chart to show, for example, X number of pills that the person was taking prior to the collision versus after the collision on an annual basis, and do a chart so that you can see it, that really what they were taking before was completely insignificant in comparison. And then you bring that back with, getting the background information on how active were they, were they volunteering, were were they working, how were they functioning, and you use all of that together and you paint a picture to show that despite the fact that they had these pre-existing medical problems, they were still able to function at quite a high level. With regards to the particulars of the collision, we get a lot of details from the client from the get-go, because whether or not liability is going to be contentious, we know that they're going to be asked a significant amount of questions about, they're going to be asked a significant amount of times throughout the litigation, whether it's at the discovery, by different medical assessors, by the doctors that we send them to, and so on and so forth. So I've put here just some of the questions that we ask, and of course there's follow-up questions that we ask as well, but we get some background information which is outlined here, and then go through and get details about the driver action, the vehicle action, the speed, the direction of travel, the damage, details about where the damage is, about any charges, and so on and so forth. We try to get very specific, detailed information with regards to whom they spoke with, what happened during the impact, seatbelt involvement, airbags, and so on and so forth, again, because we are trying to find out this information, not just for liability purposes, because in a lot of cases liability is a non-issue, but for damages purposes, we want to build that information from the get-go. We know very well that the impact, how it happened, and the force of the impact is something that would be taken into account by juries in the future. So we want to get as much detail as possible from the beginning. We go through a very detailed analysis of the client's injuries, and we literally go through this checklist every single time and ask very specific questions about the client's injuries and symptoms. So we cover physical, psychological, cognitive, and neurological. I have found that over the years that clients tend to focus on the physical, and once you start exploring and specifically asking them the questions and listing the symptoms and asking them whether or not they have these symptoms, more often than not they are actually experiencing them, but it's just not information that they volunteer because they're just not focused on these symptoms, or some of it might be cultural. For example, you know, in some cultures it's really frowned upon to have any psychological symptoms, so they won't come out and just admit those things. So it's very important to ask the specific questions and ask them to make sure that they are providing us with updates as they're coming in, and that they're describing these symptoms and injuries to all of the doctors, all of their treatment providers every single time, and making them understand how important it is that they explain all of their symptoms, so that, for example, there can be a consistency in the medical records with regards to what they are going through, and also so that their family doctor and any other doctor that they see can do proper referrals for them. We get general information about their treatment providers, so that then we can start exploring what medical information we need to obtain to support the case, specific information with regards to their medication, what's been prescribed and what it's for and who's been prescribing it, whether there's been any refills or any previous prescriptions. Again, it depends on what stage we are having the clients sign up. Usually most clients sign up fairly close to the date of the collision, but that's not always the case. We try to get as much information as possible with regards to collateral benefits. We want to find out whether or not there's any coverage for LTD, any medical coverage through their employer, through their spouse's employer. That's very important to find out. I want to get this information. Yes, of course, I want to find out whether or not my clients have access to more funding, which will help in payment of their expenses, but it also helps to build the burn rate. So, for example, if somebody is spending, you know, on average $5,000 per year based on what's being approved by the insurer. And then on top of that, they have coverage for whatever it is, let's say another $2,000 of coverage between psychological and physical. That increases their annual burn rate from $5,000 to $7,000. And that's information that I find is helpful in trying to negotiate, in trying to obtain a number for future healthcare cost expenses or medical rehabilitation benefits when you're negotiating with the accident benefits carrier. We want to find out whether or not they were receiving ODSP, if they were on social assistance, if they were receiving CPP, EI, long-term disability. This is all information that you need to obtain, both at the time of the collision, but also you need to explore it later on. Sometimes I find that when clients are coming in and they're not able to go back to work and they've been denied their IRBs, they don't know that they can apply for CPP disability. A lot of people think that CPP disability is only available, or CPP is only available when people retire. Like, a lot of people don't know that it's available for CPP disability. So that's something that you want to make sure that clients are informed of, so they know and they can explore it with their family doctor as an option in the future if they are cut off, or even if they're not. Of course, with the section with regards to employment is critical. We want to get as much information as possible in that regard, as far as what their salary and how it worked, what their duties and responsibilities, whether there's been any return to work attempts. We get a very detailed outline of past work experience. Depending on what type of case it is, you need to understand what this means as far as their loss of competitive advantage, their potential future earning capacity. You want to know what their plans were. I had someone come in who was just recently, they were working 3 jobs. This person, she speaks 10 languages. She was in school. She's like a superhuman. We spent a lot of time, we spent hours exploring all of that, because of the collision, she can't explore all of these avenues. So we're going to have to gather all sorts of information as far as business plans that she had, projections for future earnings that she had drawn up. She's missing out on a lot of networking opportunities in her community. I asked her to track all of those so that we can have a better understanding of what her potential was, because right now she was earning decent income, but the plans that she had and the direction that she was going in would mean that she would be able to multiply her income by a number of times in the near future. And she has a lot of information to back all of that up. So we spent a lot of time exploring that so that I could better understand it, and I can teach her what I need from her, what documents I need, whom we need to speak with, whom we need letters from, in order to be able to build that in significant detail. As far as the housekeeping and home maintenance is concerned, it's important to explore the size of the home, the size of the lot, the number of bedrooms, bathrooms, how many cars fit in the drive, is there a finished basement? If there's a finished basement, that means extra square footage. In a bungalow, that means double the square footage to clean. You want to understand how many vehicles can fit in the driveway, because we need to understand, obviously, what level of maintenance, what type of gardening was this person doing. This is a hobby, you know. Do they have pictures of what their garden looked like before and after the collision? That's important for us to explore. We need to explore who is assisting them with their housekeeping and home maintenance now, and in detail as well. Sometimes they're just getting a family member to assist them, and in those situations, obviously, we know that if in the future they end up being cat, we're going to have a problem with proving, with having an economic loss unless they're actually taking time off, or proving that it was incurred. So those are just things that we try to explore from early on. so that we're prepared as the case is going along, prepared and building the case. Attendant care, the same thing. We explore in a lot of detail what the person's limitations are, who is helping them, and whether or not we are going to be able to prove economic loss. I encourage clients to, from the get-go, to use an outside company. I know that, and it's completely understandable, but a lot of times clients don't want that. They want a family member to be assisting them instead of having an outsider come in, and it makes a lot of sense. Anybody can understand that, but unfortunately the way that it works now with the accident benefits, that's not very helpful. So I try to get them to agree to outside help when possible, if they don't have someone who's coming in and is either a PSW or is actually suffering an economic loss. It's important to also do a lot of follow-up meetings with clients and continue to explore this and get updates on this. With regards to caregiver, we explore what the responsibilities were. Different age groups of children will need different responsibilities. Some kids are more independent than others. Sometimes it's caregiving for an elderly person. So I try to explore, for example, if somebody comes in and says they have 4 siblings and they're the ones who are responsible to take care of their elderly parents, I am going to explore that, because I'm already thinking what will the defense lawyer think? The defense lawyer might think, well, why weren't any of the other kids helping in that regard? So you have to explore. Sometimes there's cultural reasons why that child is the one that's responsible to take care of the parents. Sometimes it's geography, whatever the case is, but it's important to start exploring how can we prove what this loss is. Whom do we need letters from? Whom do we need witness statements from? What photographs do we need? What other evidence do we need? Hobbies and activities are very important. We explore what they were and what limitations they have. What types of activities were they doing? Were they attend the gym, for example? If they did, then I want to get the records from the gym. I want letters from the person that they used to weight lift with. If they're posting pictures on social media at the gym or engaged in activities, I want to get those photographs. I also want to tell them right from the beginning to please stay off of social media. And I often tell clients a couple of stories where I've had social media really damage the value of clients' cases, because I have had experiences in the past where we've told them, we tell them verbally, we send them letters, and I've had people, for example, open up social media accounts under a different name, for example. So I will tell them stories where they've completely destroyed their cases doing that. But just back to hobbies and activities, it's really important, and for everyone's case, but especially students and people who are retired, because we have to really spend a lot of time exploring the level of limitation that they have and what was important to them in their day-to-day activities. So with regards to building the file, I've covered some of these, but I always tell the clients right from the beginning, you can expect that they will do surveillance on you. I have no idea which cases they are going to do surveillance. I don't know when they are going to do surveillance. There are times where I had this one case, the property damage was pretty bad. He wasn't back to work. There was no red flags, and I don't know why, but they did surveillance of him within the first 6 months of the collision. There was no reason to do surveillance, and they actually caught him having an affair. So yeah, you just don't know when they're going to do surveillance, and I tell them that if they are going to do surveillance and they're good, you'll have no idea that they're doing it. You'll have no idea they're doing it, but that if they're not good, then you'll see them. So I remind them to please let me know so that I'm aware, but I also always remind them, both with males and females, but I stress it more with female clients, that if you ever feel like your safety is compromised, then don't just think my lawyer Michelle said it's surveillance. You know, if you feel your safety is compromised, call the police. But they have to be aware, and I remind them, it doesn't really matter if they do surveillance of you, as long as you're telling the truth, and as long as you are outlining what your limitations are truthfully every time that you go to doctors, then there's no issue. They can do surveillance of you all they want. Again, as I mentioned already with social media, I remind them to deactivate their accounts. When I tell this to teenagers, they look at me like I'm evil and I'm cutting off their oxygen, but then I try to get their parents to help me. And I tell them a bunch of stories, as I mentioned, but I spend a lot of time stressing how important it is, and especially when the client is really young. I remind them of their duty to mitigate and stay active in treatment. I'm not about to tell them, you know, go to treatment just to build your case, but I do remind them that they have to follow the advice of their medical team, and they have a responsibility to try to continue to get better and do what they can to get better. A lot of times clients will ask me, oh, you know, can I go back to work? Do I still have a case if I go back to work? And I always remind them, we're not the type of law firm who's going to tell you to stay off of work so you can have a bigger case. What I tell them is, listen to your body, pay attention to what symptoms you're having, and listen to your medical team. That's how you're going to decide if you're in a position to go back to work or not. I remind them that every time that they go to the family doctor, to an assessor, that we send them to a specialist, to an IE, to the physiotherapist, psychologist, doesn't matter who it is, that it's very important that they outline all of their symptoms every single time and all of their limitations. And I tell them, see how we just spent, you know, an hour or 2 hours, whatever it was, going over all of your limitations and all of your symptoms, and you're probably wondering why I'm asking you all of these questions, like, for example, do you have limitations kneeling when you pray? You're wondering why I'm asking you those questions, but I want you to be very detailed because those things are important to you. I remind them to give us all of their expenses. Every month I tell them, just put all of your expenses together, whatever it is. If you're buying a special cream, if you have to buy a special pillow, whatever it is, send it all in an envelope and give us all of that information. And of course, communication with us. It's very important that we know that, for example, they've gone back to work, that they have an appointment with a new specialist, that they have an MRI coming up. I find that helpful, even if I'm, you know, in settlement discussions with defense counsel. I might not be able to give a counter proposal if I know that there's another MRI coming up, or there's potentially a surgery that's scheduled, or whatever the case might be. So I remind them to give us all of that information. If anything is happening that we need to know, communicate it to us. Don't just wait for our next follow-up appointment. From the beginning, we spend a lot of time, as I mentioned previously, exploring potential lay witnesses, family, friends, coworkers, doesn't matter who it is, but we spend a lot of time exploring all of those different potential witnesses with them. And then what I do is I will put it right into my letter that I send out, enclosing a copy of the retainer and confirming our meeting. I will remind them, because they're overwhelmed. They're getting so much information. There's so much paperwork, so many things to sign. So I will actually put homework for them in there. Like, for example, if they say, you know, I have my boss who's willing to write a letter for me, and I have my rabbi who can write a letter for me, and the person that I used to jog 5 kilometers with every Sunday will write a letter. So I will literally write their names and tell them to let us know, will you get letters, or do they want us to contact them? Please get our permission to contact them. Basically spoon feeding them so that it's easier for them. It's easier for them to just follow and get what we need. We'll give them, if they want, draft invoices for housekeeping, attendant care, caregiver expenses, or tell them to go out and get them themselves. And we remind them if they're using family or friends, you still have to keep track of it. Again, remind them to go to their family doctor regularly to apply for STD and or LTD. I have, over the years, noticed a lot of times it's really hard to get family doctors to send clients to specialists. A few times I have family doctors that will send clients to every specialist that they need to go to and every diagnostic testing. Sometimes clients come in and they say, you know, I'm having all of these symptoms. I'm talking to my family doctor. My family doctor's rushing me out. So I'll remind them that it's important for them to speak to their family doctor about any potential referrals that they could be making. Like, for example, a year and a half after the collision, their shoulder is still hurting them tremendously and they have no range of motion in their arm, their shoulder, they can't elevate it, whatever the case might be. I'll tell them, you know, speak to your family doctor, ask for a referral for an MRI or for an orthopedic surgeon or whatever the case might be. If the defendant has been charged, I remind them to make sure that they are attending and giving evidence if they're called upon to give evidence. I remind them to, as I mentioned, with regards to the monthly out-of-pocket expenses and to provide us with the proof of economic loss as far as, for example, attendant care or housekeeping is concerned. Right from the beginning, we arrange an in-home assessment and attendant care Form 1 to be completed. And then we get updated ones if necessary into the future. We request the hospital records, the ambulance call report, obviously the family doctor's records, physio, OHIP, put OHIP on notice if it's a non-MVA. We request the prescription summaries, and we diarize to get a letter from the family doctor, a follow-up letter. And I start to explore what potential expert reports I'm going to get. I might not want to get anything else other than getting an in-home right at the beginning, but if I'm already contemplating certain reports, it's already going into the system so that it's already going to be diarized. Like, for example, if I know based on the injuries this person is never going back to work and I'm probably going to try to have this person deemed catastrophic, I'm going to start already telling my staff I will want this expert involved, for example, to do a future care cost report. I'll need an income loss calculation, and I'll even give, you know, a bit of a timeline at what point I will want the reports. This might change, but this way it's already in the system right from the beginning, and everybody knows what the goals are as far as how the file is going to proceed. With regards to liability, you want to get in contact with your potential witnesses right from the beginning. There might be some witnesses that your client knows about. There might be some witnesses listed in the police file. Maybe you need to bring a motion to get the complete unredacted notes and access more information. You want to get the 911 dispatch records, the fire department records. They could list all sorts of information that the police don't have. I can't say that I go to the scene every single time. I don't, but some I do, because if liability is highly contested, you should absolutely go, and you want to go early on, and you want to get your experts to go early on as well. There might have been, for example, a camera that has footage capturing the collision. Maybe the police didn't ask that storefront if they had a camera. Maybe they asked a different one that didn't have it, or whatever the case might be. Send your clients back to the collision scene to take photographs. Usually, if whatever was happening, they're focused on, you know, getting in the ambulance, they're overwhelmed. But it's important to get photographs from your client. Get photographs from everyone. So you want to ask all the potential witnesses whether or not they had any photographs. Sometimes your clients might have sent, asked for a family member or a friend to come to the collision scene. They may have taken photographs before the police came and before the vehicles were moved. That's critical information. You want to get the weather history as well to get a better understanding of what was happening. And of course, you want the property damage file and always colored photographs. With regards to the building loss of competitive advantage, loss of income, obviously you want to get the background information, request the income tax returns, the university and college transcripts, any evidence of upcoming promotions. That they have interviews lined up, for example. I have one client where he was actually driving to an interview, and then he didn't end up getting the job, the other person got it. You want to write to the employer and find out whether or not there would have been pay raises. For example, in unionized positions, there's going to be negotiated pay raises every year, or there may very well be. Even in private companies, people get raises and pay increases. So you want to find out if this was something that was happening in this company, and if those are losses that your client may have. You want to find out about potential losses to pensions, for example. You want to get a complete copy of the STD, LTD file, and if necessary, early on retain an expert to calculate the income replacement benefits if that's going to be an issue, for example, with self-employed people. You want to do that from early on. Students are a bit more challenging, obviously, because they don't have a work history, so you have to be a little bit more creative. You want to get information from their professors, from maybe student involvement, organizations at the school or the university they may have been involved in. You want to get information from other students. For example, they might be going to school with somebody that they were helping during every class, helping them take notes, helping them study for exams. They may have had a study partner, whatever the case might be. You want to explore that in great detail. You want to explore the family, education, and achievement history. So you want to, it doesn't mean that, if they come from a family of doctors that they will automatically be a doctor, but that, if they say those were their goals and, they're doing really well in grade 11 biology and their parents are doctors and their grandparents and their aunts and uncles are all doctors, well, that's a pretty good lineup that you have there. And that's some pretty good evidence that this student would have been going in that direction. Elderly and retired clients, the activity level and the recreational activities, social activities is even more important. The prescription and medical history charts, which I've already explained, I think are critical, especially with these clients. And then you want to explore with the elderly, and I'm saying elderly now because now a lot of people are retiring younger and a lot of people are working a lot later, so things have changed. The retirement at 65 isn't the case anymore. But for older people, you want to explore life expectancy. So if I have someone come in and they're, whatever the case might be, considered elderly, I want to find out at what age did their parents pass away? If they know what age their grandparents passed away, do they still have siblings that are older than them or close in age that are still alive? Do they have uncles and aunts that, died at 100? You want to find out the family history as far as life expectancy. That's helpful information. Of course, you want to start contemplating the expert reports. I've already gone over most of this earlier, but just a couple of things. You want to make sure that you're contemplating these early. It doesn't mean you get them early, but you have to serve them early enough. You want to give enough information, and you want to rely on experts at the right time so that the insurance companies have sufficient time to be able to, attend a committee meeting, potentially change the reserves before they get to the point where they're negotiating with you. And when you can use treating specialists, use them whenever possible. If you can get the treating orthopod to say that this client will need 2 more surgeries in their lifetime, that's really powerful. Communication with the adjuster. So you want to get to know the adjuster from early on, give them what they need, explain away discrepancies. Like, for example, let's say the client hadn't been working for 6 months, but before that they were, explain why the client hadn't been working. Maybe the client had to, I don't know, maybe they were taking a course to make themselves a stronger candidate for a promotion they were pursuing, or whatever the case might be. Outline the strengths in the case, but also make sure that you are providing background information for the weaknesses in the case when you're speaking with the adjuster. So I love Maya Angelou, so I always have to put one of her quotes in there. It's a lot of work building cases, and like her famous words, nothing will work unless you do. So it's a matter of working with the clients, having the clients understand that they have to work with you. It's not just, oh, now I have a lawyer and my lawyer is going to take care of everything. They need to understand that they have to work with you to explain their injuries, explain their symptoms, and do what they can to support their claim as well. I'm going to pass it on to Stan. When we were discussing this webinar and we were talking about the topics, I mentioned something that we give our clients during discovery prep. So we have them come in and then I give them homework. Sometimes I give this to them ahead of time if I know that a discovery is coming up and they're, you know, some clients are super organized and on top of everything. Sometimes I like to leave this closer to the discovery date. But I ask them to list all of their activities that they cannot do in all those different categories, work, housework, etc. And then I also ask them to list all the activities that they can do, but pain and or medication in the same categories. And I'll get them to list all of their medications and all their symptoms broken up in the different categories. And I'll ask them to send me their homework in advance of the discovery. So if I prepare them the day before, I tell them they have to send it to me that evening, and I will sometimes email them back or speak to them in the morning and say, okay, well, what about the fact that you said, you know, you used to go hiking every other weekend in the summers, or you know, there's something that they did that was special with one of their friends, or something that they did at work that they can't do anymore. So sometimes they don't put a lot of detail, so I remind them that they have to include a lot of detail in these categories, because these are the areas when they're at a discovery where I'm going to want them to give a lot of detail. All right, I am going to pass it on to Stan.
Well, first of all, Michelle, thank you very much. Good afternoon, everyone. Thank you all for attending. I'm going to be discussing two areas. The first area is preparing your client for examination for discovery, and the second area is preparing your file for mediation and or pretrial. First of all, I should say that Michelle's Michelle's idea of giving your client homework before examination for discovery is actually a very, very good idea. And frankly, I haven't done it, but I think I'm going to adopt it. But anyways, with respect to preparing your client for discovery, as you all know, the majority of cases settle before trial. And therefore, from where I'm coming from, examination for discovery is probably the most significant event in the entire litigation process. And it's an event that you absolutely have to take very seriously. The defense counsel that you're going to encounter at discovery, aside from simply asking your client name, rank, and serial number, defense counsel is sizing up your client. And that's probably more important than the actual questions and the actual answers. And when you're preparing your client for discovery, keep that in mind. You can't remake your client. Everybody is different. Everybody comes from a different walk in life. That won't work. But a good preparation for discovery, you can perhaps improve your client's presentation a little bit so that the defense lawyer walks out of discovery with a more favorable impression of your client. you should spend a lot of time in your office with your client preparing him or her for discoveries. I would suggest 2 to 4 hours for every case, sometimes even more. I know my meeting with my client is routinely 2.5 to 3 hours preparing them for discovery. With respect to timing of that meeting, I think it's best to do it very close to the actual day of discovery. 2 days before is perfect. 3 days before is good. I don't like to do it any more than 2 or 3 days before, because the client will forget a lot of what you say. And also, you're in a better position to prep them 2 or 3 days before their discovery, because you've got the file out and you're up to speed on it as well. The first thing I try to do with my client when they're in my office preparing is to put them at ease. I think you all know this, that most clients are very, very nervous about having to undergo questioning by the opposing lawyer. Most clients' only knowledge comes from watching television. And as you all know, examination for discovery in the cases that we do is nothing like what your client might have seen on television. I emphasize to my clients that they are not going to be grilled by opposing counsel, that opposing counsel has probably only looked at their file 2 or 3 days before the discovery, and that opposing counsel really just wants to find out how old they are, where they live, where they work, what kind of injuries they sustained in the accident, etc., etc. I also spend some time at the beginning explaining to my clients what is actually going to happen. I tell them where we are going for discovery. I explain to them what that office is. It's a court reporter's office, or it's a discovery office. We even discuss where it is. I make sure that both I and them know we're going to the same place, so that at least in Toronto we don't accidentally wind up at the north office when we should be winding up at the south office. I go to the lengths of explaining to them the size of the room that they're going to go in. I tell them who is going to be in the room with them. I make sure that I tell my client that I will be sitting beside them for the entire discovery. Believe it or not, the clients have no idea of this. A lot of them think they will be alone with the opposing counsel, and I find that they find this very comforting when I tell them that I'm going to be sitting right beside them, just to make sure that everything goes properly. Thank you. It sounds trite, but I also tell every client very early on to tell the truth. I also make sure I tell my client that they're not the kind of client that I'm worried about not telling the truth. I always tell them that I have always found them in my dealings with them up to that point very truthful. And I tell them, but this is something I tell everybody. But it still, I think, needs to be said out loud to your client to make sure you completely tell the truth for all the answers you're going to give. Then I tell them to listen very carefully to the lawyer's questions. And I tell them not to begin to answer their question, to give their answer until the question is completely put to them. I tell them that my perception is that the human brain, just like when you Google something, the lawyer will ask the first half of the question, and the human brain will give the client what the brain thinks the second half of the question will be before the second half of the question is actually asked. As I said, the same way as when you type a query into Google, it anticipates the rest of your question. So I tell them not to do that, because I tell them that every once in a while, the question you're going to be asked is not what your brain told it was going to be. So I tell them to wait until the lawyer completely finishes. Then I tell them to take a breath, wait a second or wait 2 seconds before they answer, to digest the question. I also make sure to tell them that they should make sure that they completely understand the question before they begin to answer it. And I tell them not to be afraid to say to the lawyer to clarify the question, or that they don't understand the question. Many clients are afraid that if they are perceived, or if they think they say to the other lawyer, I don't understand the question, that the lawyer will think they are dumb or something like that. And I emphasize to them that that is not the case. I emphasize to them that every defense lawyer asks questions in a different way, and that some of them don't ask their questions very clearly in the first place. And as you all know, since you've attended discoveries, sometimes you as the lawyer don't even know what the defense counsel is asking because of the way the defense counsel phrased it. So I tell them not to be afraid to ask for clarification, even if they have to do that 5 or 10 times during the discovery. I tell them that it is far more important that they answer the question that they are being asked rather than to guess at it. The next thing I tell my clients is to try as best they can to keep their answers short. I tell them that the best answer to a question, if it's possible, is simple yes or a simple no, and that they needn't give their life story every time they are asked a question. I also explain to my clients that examination for discovery is not a memory test. I tell them that there will be a lot of questions, things like dates and doctor's appointments, that they simply will not remember. And I often give them an example about asking them when the last time they went to their dentist was. People don't remember that precisely. They may know within a couple of months when they last saw a dentist. And especially, we have to keep in mind that the defense lawyer is going to be asking questions that may be going back 2 years, or maybe going back 3 years, or sometimes maybe going back more than 3 years. And I emphasize to my clients that it is perfectly acceptable for them to say they don't remember. And that when they're going to give an estimate, or I tell them not to guess, but when they're going to give a shot at answering the questions, if they're not sure, to tell the lawyer that they're not sure, but they think it was around this point in time, or they're not sure, but they think it was probably this. I think that's a far better way to do it. It also, again, puts the client at ease. Again, that the discovery is not a memory test, that they should be natural and just tell the lawyer what they remember and tell the lawyer what they don't remember. Then I tell my client not to give what I call guilty answers. The best way for me to explain to you my impression of a guilty answer is to give you an example. Your client might have suffered a back injury. The lawyer might ask your client, did you go for physiotherapy? And the answer to that question should be, yes, I went for physiotherapy, or no, I didn't go for physiotherapy. But most clients are terrified to simply say, no, I didn't go for physiotherapy. They feel that if they just say that in isolation, that it's going to hurt their case. So the answer comes out, no, I didn't go to physiotherapy because I had to go to daycare, my child is in daycare, or this or that. Or, you know, it could be that they didn't go to physiotherapy because their doctor said, this is not the kind of injury where physiotherapy will help you. I tell them to simply answer the question that is asked and don't give a guilty response. The guilty response is no, but, and then a 5-minute explanation. I tell my clients that if the lawyer wants more information, the lawyer will then say to you, well, is there a reason why you didn't go to physiotherapy? And I tell my client, then you can tell the lawyer, yes, there's a reason, and the reason is that my doctor told me that physiotherapy would not help with this particular type of condition. Then I discuss with my client what I call the never say never rule about answering questions at discovery. And again, the best way for me to explain, again, what I call the never say never rule is to give you an example. So let's take the client, again, who has a back injury. And the client tells you that since the accident, he or she has not been able to shovel their snow because of the back injury, and that they have hired the teenager who lives down the street to come over when it snows, and he or she, the teenager, shovels the snow for them, and they give them $10. So here's what happened in real life. In real life, one snowstorm or one snowfall, the teenager was not available. He was away for a couple of days, and he or she couldn't do it. So the client picked up a shovel, and the one time in the 2 or 3 years since the accident, pushed around a little bit of snow on the driveway because there was nobody available to do it. They come to discovery, and the lawyer says, have you been able to shovel the snow since your accident because of your back injury? And the client says, no, absolutely not. I can't shovel the snow anymore. I've been getting the teenager down the street to do it for me. Well, you can bet your life that one day in 3 years that the teenager was not available and that your client pushed around a little snow was the day that the insurance company was doing surveillance, and that was the day that the surveiller was sitting on the street, and to the joy of the investigator, got 10 minutes of film of your client pushing some snow around. So what I tell my clients in terms of the never say never rule really is, which is try not to answer these questions with an absolute. To say to the lawyer, to think about it for a few seconds and say, I don't think so. I don't think I've shoveled the snow since the accident. I don't remember having done it. I can't say 100% for certain, but I don't think so. That way, you will inoculate against this surveillance or against whatever other information the defense lawyer has. Because believe me, when you tell the defense lawyer later on, after the defense lawyer is thrilled to death that he's caught your client lying, it will fall on deaf ears when you tell the defense lawyer, the client wasn't lying, the client just forgot that one time. Come on, it was just an honest mistake. Well, believe me, defense lawyer doesn't want to hear the honest mistake excuse, even if it was, and it probably was. The defense lawyer doesn't want to hear that. The defense lawyer will be very happily report to his client about the credibility of your client. I also review with my client at this meeting their pre-accident medical history. And normally that involves a review of the family doctor's clinical notes and records for as far back as you have them. And I'll discuss that for a bit later, how far back. But again, the same problem. You'll be reviewing with your client the family doctor's clinical notes and records, and hopefully if you prepared yourself the way you should have, I don't always, but I should have gone over these clinical notes before the client is there, and I should have red flagged any entry in the 2 or 3 year period in the doctor's notes that any notation of a prior injury or a prior complaint that is similar to any of the complaints the client is now having, so that I can discuss that with the client. But invariably, you'll find something 3 years before the accident where the family doctor's records say back pain plus. And then when you read a little bit further, you learn that what the client had something like a kidney stone, which is very painful and can present with back pain, and the client went to see the family doctor with the kidney stone. But if you don't have the clinical notes and records and you don't specifically point this out to your client may very well, and again, innocently, not remember that 3 years before the accident, he went to his doctor with the kidney stone and was telling the doctor that my back is really aching because of this kidney stone, because probably the whole thing cleared up in a week or two, and your client has completely forgotten about it by now. And again, it's a credibility issue. Even though the client innocently at discovery says, no, I never had a back problem before, never complained to my doctor about back pain, because the client, first of all, innocently forgot about it, and second of all, isn't associating the kidney stone with a back problem. So if I'm able to decipher this from the clinical notes and records, I'll go over it with the client. The client will say, oh, yeah, now I remember. And then a few days later at the discovery, when the lawyer says to the client, have you ever complained of back pain before this accident? The client will be able to exactly say, well, a few years ago, I'm not sure how far, a few years ago I had a kidney stone and it was killing me, it was hurting my back, and I went to see my doctor about it. So that's about all I want to say about preparation for discovery. I'm going to move on to my next topic, which is preparing for mediation and or pretrial. So again, I will say that mediation and or pretrial is usually the most important opportunity you will have to try to negotiate a settlement of your client's claim. And again, since the vast majority of claims will settle before court, the mediation, if you have one, or the pretrial conference is extremely important to your case. Now, as you all know, or hopefully you know, outside of Toronto, Ottawa, and Windsor, there is no mandatory mediation. And unless mediation is voluntarily agreed upon, which I understand it often is even out of town, it will be your pre-trial conference. You will go straight from your completion of your examination for discovery some months later to a pre-trial conference. That will present to you your opportunity to explore settlement. I find that much of the preparation I do for either mediation or pretrial conference is similar, and there's a lot of overlap. I remember attending an OTLA conference a million years ago when I was a young OTLA member. And I remember John McLeish giving a presentation. And I always remember his words. And he told us that he begins his preparation for the pre-trial conference. I think this was even before there was mandatory mediation. It was so long ago. And he told us that he begins his preparation for the pre-trial conference with his initial client interview. And I think that's a very good takeaway. At least that you start thinking on the initial client injury a year and 2 years and even 3 years ahead. What do you think this case is going to look like in 2 years from now, as opposed to what it looks like now? And I think if you're always thinking a year or two ahead, I think that will help you get your case ready as you proceed through the various steps. But I find that much of the practical aspects of getting your file ready for mediation or pretrial is done following completion of examination for discovery. Of course, you need to follow up and make sure that you have all of the clinical notes and records and medical reports and X-ray interpretations that you need. That's critical. Then you have to make a very early decision, I think, about what experts you're going to need to retain. I don't find it commonly done among the plaintiff bar that the expert reports are done before discovery. Most of the time, they're done after discovery. But even with respect to your expert reports, you have to consider timing of it. You may consider that you need a future care cost report. You may need an economic loss report. But you realize, or you should realize, that before you can engage your economic loss expert or engage your occupational therapist to do a future care cost report, you have to have your physiatry report or your orthopedic surgeon report to provide the other expert, so that the other expert can use that as a basis for doing their report. So you have to come up with a schedule for which expert is first, which expert is second, and you have to start to get those arranged. I think you will all know typically how long it takes from the time you tell your law clerk or your assistant, please get a hold of XYZ Assessment Center, or please get a hold of Dr. Smith's office and see when he or she can do a medical legal on our client. How long it is between the day you say that to your assistant and the day you actually have the report on your desk. It can easily be 4 or 5 or even 6 months. So that's why you have to start this process early. And especially if you then have to get your first set of reports over to your second set of experts, that's going to take another 2 months or so to get the second set of expert reports. You should serve your expert reports as soon as you can and as early as you receive them. Some lawyers will let them pile up until they've got 3 or 4 expert reports and serve them all at the same time. I don't know if that's such a good idea. I think the earlier you get them to defense counsel, the better. And as you all know, defense counsel are constantly complaining that they are receiving the plaintiff's expert reports too late in the process. And well, really, do we really care if defense counsel is complaining or not? Is that my problem? Well, the answer is yes, it is your problem if defense counsel is complaining, because as we all know, defense counsel gets your expert report, defense counsel has to review it, has to report it out to an insurance company. At an insurance company, the file may have to go through several hands before any changes can be made with respect to the valuation of your client's claim. And if you get the report to the defense lawyer too late in the process, it will be too late for the insurance company. And I find that the longer I practice law, I find that insurance companies over time have become 10 times more bureaucratic than they were maybe 10 or 15 years ago, with more layers of authority that an adjuster has to go through, and more administrative things like that. So the earlier you get them to defense counsel, the better chance you have of those reports resulting in a reevaluation of the value of your client's claim by the insurance company. With respect, if you're going to private mediation, I think you should have all of your expert reports served at least 1 month before the mediation. 2 months is even better for the exact same reason. For those reports to have any value at the mediation, they have to go through, on the defense side, several hands, 2 or 3 or 4 sets of hands, and invariably you learn that when the defense lawyer sent your expert report over the insurance company, the first level insurance adjuster was on leave of some kind, was on vacation of some kind. The second level of authority at the insurance company didn't work there anymore. And one complication after another. And who loses out with all these complications? The plaintiff loses out. So the earlier you get them over there, the better. In terms of a pretrial conference, we know that the rules of civil procedure require you to serve all of your expert reports at least 90 days before the pretrial. With respect to your actual mediation memorandum or your pretrial conference memorandum, it would be really nice if I told you that I serve them at least 2 weeks before the mediation. I think really that's probably when we should do them. I have not been able to get them out 2 weeks before the mediation. My goal is 7 to 10 days, with my absolute shortest deadline of 7 days before a mediation. With respect to pretrial, the rules provide a number of days that you have to file it. I think it's 5. I'm not quite sure, but you shouldn't wait and do it on the last day that you're allowed. Again, the earlier you can get it sent to defense counsel and served and filed in court, the better off. I have heard anecdotally from defense counsel that they often get the plaintiff's mediation memorandum the day before the mediation, 2 days before the mediation. For 2 reasons, I don't think that's in the best interest of your client. First of all, what I have found in the last few years is defense counsel does not even do their defense mediation memorandum until they get yours. So if yours is only getting delivered 2 or 3 days before the mediation, then you're going to get the defense counsel's memorandum the afternoon before, and it's going to be brief and it's going to be poorly done. And again, that's not going to help. Second of all, I think that if you're serving your mediation memorandum 2 or 3 days before the mediation, I think that's sending a signal to defense counsel that you aren't taking the claim very seriously. And I think that does a disservice to your client. So get them out early. It's hard to do, but I don't think we have any choice. You need to prepare your client for the mediation or the pretrial. And I think it's a personal choice. And again, for me, it depends on the circumstances, whether I have the client into my office for a face-to-face meeting before a mediation, or whether I discuss it on the phone. For sure, I spend 15 or 20 minutes on the phone with my client explaining to them what's going to happen at their mediation. And that can be a month before the mediation commonly. I find my clients are very comforted, again, when I tell them that the mediation is nothing like their examination for discovery, that they're not going to be asked any questions, and that if they wish, and I tell them this is common, that they don't have to say one word at the mediation, that I, as a lawyer, will do the speaking. I explain to them what mediation is about. I explain to them that it's an attempt to settle their case. I again explain to them where we're going. It's often the same place as we had discovery. I explain to them where we're going. I tell them how long it's going to last. I explain to them what's going to happen with that I'm going to prepare a mediation memorandum that explains their case, deliver it to the other side, etc., etc. And again, I think this helps put the client at ease, especially when I tell them that they will not be asked questions at the mediation. There are a bunch of other considerations or things you need to do more for pretrial conferences than for mediations. I won't go into all of them, such as you have to put your mind to the length of your case, because you have to tell the court you need to start seriously putting your mind, or you should have done this even before, to who you're calling, your witness list. You should be actually not only doing your witness list for the pretrial, but getting a hold of the witnesses and checking their availability, especially your experts, because you will find out that that expert is going to be on sabbatical and out of the country for the 3 months that your trial is about to be scheduled for. So the earlier you find that out, the better, and all those types of considerations. Another thing to consider is whether you, and this applies as much for mediation, but more for pretrial conferences, because the pretrial conference can often be a year after a failed mediation. Pull out your expert reports. Almost invariably, you're going to need to get them updated. And you want the update reports available for the pretrial conference. So you, again, at least 6 months in advance, you got to get a booking for your client to go back to see the expert to get an updated report. That completes what I want to say about the 2 areas that I'm going to talk about. So, Ms. George, now what?
Now I'm going to ask you some questions. Now I will interview you, Stan.
Hi guys, it's Jeff here. We're running a little late, and we've just got 1 question in, so if you want to ask that question, and then we'll conclude the webinar, and we'll let everybody get on with their day.
Well, Michelle talked too long, that's
Sorry.
No, longer is better than shorter. Great value for our attendees, so thank you both. But no, certainly we have time for 1 question.
So, where's the question?
The question is, do you routinely request per-accident family doctor's records and have them available to review with your client? If yes, how many years back do you request?
Well, that's a very good question. I routinely request pre-accident clinical notes and records 100% of the time. I have heard, again, anecdotally, that some plaintiff lawyers don't want to request pre-accident clinical notes and records. They wait for the discovery. And if the defense lawyer says, would you please request 2 years of pre-accident clinical notes and records, they say, yes, I'll make that request. And meanwhile, they're sitting there at the discovery. They've never seen a pre-accident record. Their client has never seen a pre-accident record or been able to discuss pre-accident records. And I think that's a huge mistake. So I don't have an exact number of years back that I routinely request, but at least 2 years of family doctor's records I routinely request. And that's early on. Maybe 3 years depending on the case. I really don't think it can hurt you. The more the better. Even going back 5 years, I don't see how it can hurt you. So I think that's the answer to that question. I'm going to turn it over to Michelle to see what she thinks of that.
Yeah, no, we normally request 3 years pre-collision. And for this, I'm just going to echo what Stan has already said, but I think it's so important to have a full understanding of your client's medical history, and you can't just rely on the information that the client is giving you. I think you're almost doing them a disservice if you don't have all of that information, if you can't help properly prepare them before discovery or anything else. And also, by the time you get to the discovery, quite some time has already gone by. Whatever doctors you've sent your clients to, they haven't had the benefit of having the pre-existing medical history, which I think is also very important for them to have when they're drafting their reports.
I have a question for Michelle.
We don't have any more time for questions.
Quick. Do you ever get expert reports pre-discovery?
Sometimes, not often. It depends on what stage the discovery is taking place. So yes, there are some.
And I'm talking about a medical expert,
yes,
not a financial one.
It depends. Sometimes it does happen that we already have some medical experts before. Medical expert reports completed before the discovery, but usually they're being completed around the same time that the discovery is being booked, the discovery is taking place, or after the discovery more will take place. But we do have normally an in-home right from the beginning, an in-home assessment.
All right. Well, thank you, Michelle and Stanley. That was very informative. And thank you, attendees, for joining us today. There's a brief survey that will pop up once this program ends. Please take a couple of seconds to give us your feedback. We appreciate it. Our next big event is our LTD conference on September 19th in Toronto. The theme of the conference is litigating the long-term disability case. You can attend in person or via webcast. Our next webinar in the ABC series is ABCs for SABS on October 7th. And of course, our fall conference is on Friday, October 25th. We hope to see you all there. You can find more details in the full events list on outla.com by clicking on Calendar under the CLE and Events tab of our main menu. On behalf of our speakers, our sponsor Seahold, and the Ontario Trial Lawyers Association, thank you for attending our presentation and have a great day.